Welcome to the deep dive. Today we're diving straight into the engine room of negligence law. We all know the basic rule. You must act like a reasonable person. But when a case goes to a jury, how on earth did they take that slippery subjective concept, the feeling of fault, and translate it into a concrete finding of liability?
That translation is the core mission of this deep dive. We're giving you the blueprint for breach. Forget feeling overwhelmed by the facts of a case. We're going to provide a precise, structured way to dissect whether a defendant's conduct was genuinely unreasonable.
Absolutely. We will unpack the essential analytical tools courts use to assess unreasonableness. First, we need to understand the policy rationale for the entire fault system. Then we dive into the infamous algebraic equation, the hand risk calculus, and finally we examine the crucial role and, well, the limits of industry custom in defining safety. Okay, let's start with the philosophy. Why are we only liable for unreasonable risks? Why not hold people liable for every harm they cause, regardless of, intent or care?
It comes down to two foundational pillars, really. First, as Justice Oliver Wendell Holmes observed, society values freedom of activity. I mean, if we held people liable for every single accident, we'd stifle all beneficial activity simply because it carries some inherent risk.
Right, innovation would just stop.
Exactly. We accept certain unavoidable accidents as, well, the cost of a functioning society.
And the second pillar, that sounds more like the economic angle.
That's Judge Posner's insight. He argued that the SALT system's dominant function is economic efficiency. Look, we don't want 100% safety because, frankly, that would cost infinity. The rules should incentivize prevention only up to the point where the cost of precaution is less than the expected cost of the accident.
So we only want the cost-justified level of safety.
Precisely. Just the right amount, economically speaking.
That economic justification brings us directly to the foundational tool judges use to structure this analysis, the legendary hand risk calculus. What exactly are the factors this formula balances?
Right. The approach that has become, well, almost gospel in torts is Judge Learned Hand's algebraic formula. It balances three factors. P, which is probability, likelihood of injury happening. L, that's loss, the magnitude or seriousness of the injury if it happens. And B, the burden, basically the cost or sacrifice the defendant must make to avoid the risk.
And the ultimate algebraic condition for breach is BPL. So the defendant breaches their duty if the burden of avoidance is less than the probability of the accident multiplied by the likely loss.
It's it. Essentially, if prevention is cheap relative to the expected accident cost, you have to do it.
If P times L, the expected accident cost, is greater than B, the cost of prevention,
then the defendant has been economically inefficient and therefore negligent. That's the core logic.
Okay, let's unpack this using the case that really cemented the formula for American law. United States v. Carroll Touring Co. What was the central, frankly, kind of silly mistake that set this case in motion in that crowded New York harbor?
Well, the facts involve a major shipping operation where several barges broke loose. But the key fact, the legally important one, was that the bargee, the attendant responsible for the plaintiff's barge, was absent.
Absent how long?
For almost an entire working day, actually, 21 hours during wartime harbor activity. While he was gone, lines were shifted, the barge broke loose, and it caused significant damage to other vessels.
Wow. Okay, and what was the core legal issue Judge Hand had to decide regarding the plaintiff's own conduct?
The precise question was whether the barge owner was contributorily negligent. I mean, did the owner breach a duty of care by failing to ensure the bargee was present, thereby contributing to the damage?
Got it. What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The rule is the Hand formula. Liability depends on whether the burden of avoidance, B, is less than the expected accident cost, P times L. So the rule has three testable elements. 1, probability P, 2, magnitude of the loss, and 3, burden of avoidance.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, probability, P? What did they say about the likelihood of the barge drifting away?
Hand found P to be substantial. Look, this wasn't a calm lake. It was a very busy harbor, especially during wartime, subject to strong tides, heavy traffic. Given that context, the likelihood of an unattended barge getting loose and causing harm was, well, reasonably high. Not a guarantee, but definitely a significant risk.
Understood. High P. Now, what about the second element, magnitude of loss? If the barge did get loose, how serious was the potential damage?
The court found L to be significant. You've got a harbor crowded with commercial vessels, many carrying valuable cargo. A runaway barge would inevitably cause serious damage. Hand focused on the foreseeable maximum loss, the potential damage, which was high.
Makes sense. Finally, the third element, burden of avoidance, B. What did it cost the owner to avoid this entire risk? What was the sacrifice?
This was crucial. The court determined the burden was minor. The incident happened during customary working hours. The only sacrifice required was ensuring a worker was present during their normal shift, a minimal inconvenience, really, compared to the massive P times L product, just having the guy do his job.
Right. So after analyzing all the elements, high P, significant L, minor B, what was the court's final conclusion?
The court concluded that B was clearly less than PL. Therefore, the barge owner's failure to have the attendant present constituted a breach of duty. This case provides a perfect roadmap for using that economic logic to find fault, you see.
Yeah, absolutely. Let's test that probability element with a vivid contrast. Think about Lubitz v. Wells. A father left a golf club in his backyard. His 11-year-old son picked it up, swung at a stone, and accidentally hit the plaintiff. Did the father breach his duty?
The court found no breach as a matter of law. Now, the loss L, getting hit with a golf club, that's serious. But the probability P of that specific, frankly, kind of freak accident happening just from leaving a common item like a golf club in a backyard was considered minuscule.
Tiny p.
Tiny p. And the burden B of locking away every single potentially dangerous household object. It's gigantic, impractical. So when P is minuscule and B is huge, the BPL formula pretty clearly suggests no breach.
Okay, but contrast that with leaving, say, a loaded gun in the backyard.
Totally different calculation.
Yeah.
Exactly. With a loaded gun, the magnitude of loss L is enormous potential death.
Right.
So even if the probability P of an accident is relatively small, that expected accident cost, PL, is still huge and likely outweighs even a moderate burden of avoidance, B, which might just be using a cheap trigger lock or storing it securely.
So the factors are always relative to the specific risk.
Always.
Okay, moving beyond the abstract math, what role does practical reality like industry or trade custom play when a jury is determining reasonableness? Does following custom give you a legal safe harbor?
Custom is powerful evidence, but it's not conclusive. It acts as relevant evidence because it speaks directly to those hand factors we just discussed.
Yeah.
I mean, if an entire industry widely adopts a safety practice.
It suggests the burden isn't too high, right?
Exactly. It suggests the burden of avoidance, B, for that precaution, is probably low, or at least manageable. So deviating from a well-established custom is strong evidence of breach.
Let's analyze the effect of deviating from custom using Trimarco v. Klein. What were the legally critical facts in that New York apartment case? The shower door one.
Right. So a tenant was severely injured when the ordinary non-shatterproof glass in his shower door shattered. It was regular glass. The tenant sued the landlord, arguing that by contemporary standards, failing to use shatterproof glass was unreasonable.
And what was the core legal issue regarding the use of customary evidence? Could they even bring that up?
The question was whether the plaintiff could introduce evidence showing that most landlords customarily use shatterproof glass in shower doors, specifically to prove the defendant breached their duty of care by not using it.
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements regarding the use of custom.
Okay. The rule is that evidence of custom is admissible if it is well-established, widespread, and this is key developed in direct response to the potential risk involved. So the rule has two crucial elements for admissibility. First, there must be a widespread, well-established custom that the defendant knew or reasonably should have known of.
Okay, a common practice.
Right. And second, the custom must be intended specifically to avoid the same type of harm the plaintiff suffered. The reason for the custom matters.
Gotcha. Now for the court's elemental analysis. How did the existence of custom apply to the first element, the burden of avoidance aspect?
Well, if the plaintiff can persuade the jury that using shatterproof glass is indeed a well-established custom among landlords, then the defendant's deviation is strong evidence that the burden B of compliance isn't prohibitively high. The industry itself has basically proven it's feasible in common sense.
Okay. And the crucial second element, the harm correlation. Why did the plaintiff need to prove why landlords use the shatterproof glass? What's the point of that?
Because they needed to show the reason for the custom was safety, specifically avoiding cuts and injuries like the plaintiff suffered, not just safe for durability or aesthetics or because it looks nicer. This directly links the custom to the probability P factor or perhaps the PL product by demonstrating the industry recognizes this specific risk and has found a reasonable way to address it.
Okay, connecting the custom to the risk. And what was the court's final conclusion in Trimarco?
The evidence of deviation from custom is highly persuasive evidence of breach and must be admissible for the jury to consider. It's really important evidence. However, the judge stressed that custom does not set the standard of care definitively. The jury still has the final say on whether the reasonable person standard was met in this specific case. Custom informs, it doesn't dictate.
That brings us to the mirror image. What if the defendant complied with custom? Does adherence to industry standard guarantee they escape liability? Are they off the hook?
Absolutely not. Compliance with custom is admissible evidence against breach, certainly helpful to the defendant, but it's not conclusive. This is where the important concept of customary negligence comes in.
Customary negligence, meaning the whole industry could be wrong?
Precisely. The jury is free to find that the entire industry custom is itself unreasonably risky or outdated.
This is the famous finding in the T.J. Hooper, which, wouldn't you know it, again featured Judge Learned Hand. What essential principle did he establish there regarding a lagging industry? The radios on tugboats case.
Yes. Hand established that a whole calling may have unduly lagged. He was talking about the shipping industry's custom at the time of not requiring working radios on tugboats, which led to losses in a storm. He declared that courts, not industries, must ultimately determine the standard of due care. If a precaution is so obviously vital.
Like radios for storm warnings.
Exactly. If it's so imperative that universal industry disregard simply cannot be excused, the court will set the requirement higher than the custom. The law can push industries forward.
This tension between custom and the ultimate legal standard really highlights this ongoing battle for control. Is it the judge or the jury who decides what's reasonable? Traditionally, it's the jury, right, applying that flexible standard.
Generally, yes. The jury reflects the community's sense of reasonableness.
But didn't Justice Holmes try to kind of override the jury and create fixed, judge-made standards of care for predictability?
He certainly did. Most famously in Baltimore and Ohio, Railroad Company Goodman. Holmes was genuinely concerned about the unpredictability of jury verdicts and sought to introduce fixed, bright-line standards for every recurrent fact pattern, like crossing railroad tracks.
What was the shockingly rigid standard Holmes attempted to lay down in Goodman? It sounds kind of crazy now.
It does. Holmes mandated that whenever motorists crossed railroad tracks with an obstructed view, they were always negligent. As a matter of law, no jury needed, unless they stopped their vehicle, physically got out, walked to the track, looked both ways, and then got back into cross.
Wait, he really expected everyone to hop out of their car on active tracks every single time? That seems wildly impractical and, frankly, potentially more dangerous in many situations.
It does seem that way in hindsight.
So how did the Supreme Court later reject this stop, look, and listen and get out approach in Pecora v. Wabash Railway Co.?
Justice Cardozo, writing for a unanimous court just a few years later, firmly rejected fixed rules like Holmes's. He argued they lacked the necessary flexibility to account for the countless variations in real-world situations. Cardozo specifically noted that getting out of the car on a busy track, as Holmes demanded, could actually create more risk.
Yeah, no kidding.
So the flexibility of the jury, applying the general reasonable person standard to the specific facts, ultimately carried the day over rigid judicial mandates. The jury's role was reaffirmed. Hashtag outro. Okay, so if you're facing a negligence question, maybe on an exam or just trying to analyze a situation, use this mental framework to synthesize the elements we've discussed. It's a quick sort of four-step diagnostic process. 1. Identify the standard. Always start here. Did the defendant fail to act as a reasonable person under the same or similar circumstances? 2. Apply the Hand formula, BBL. You really have to address all three factors explicitly. Ask yourself, was the burden B less than the expected cost of the accident? P times L. Analyze P, analyze L, analyze B. And remember, it's an objective standard. The defendant's specific financial situation, whether they're rich or poor, is irrelevant to calculating B. 3. Evaluate custom evidence. Was there a relevant custom? Did the defendant deviate from it? If yes, like in Tremarco, that suggests B was low and is strong evidence for breach, provided the custom relates to the harm. Did the defendant comply with custom? Then you have to ask, is this one of those rare cases of customary negligence where the whole industry is lagged, like in a T.J. Hooper? Could the jury still find the custom itself unreasonable? And 4. Determine the trier of fact. Based on all that evidence, is the balancing of P, L, and B so clear-cut one way or the other that no reasonable jury could find breach, allowing the judge to decide it as a matter of law? Or, as is usually the case, is there enough evidence, enough debate about the factors to send the final balancing question to the jury, the traditional arbiter of reasonableness?
That framework is incredibly helpful. The hand formula gives us this clean, almost scientific way to try and measure fault. BPL, it sounds so rational. But the minute you turn the concept of justice into an algebraic equation, you inevitably open the door to critics. People argue that this kind of economic rationality doesn't capture the full scope of our moral responsibilities to each other, things like care, community, avoiding harm, even if it isn't strictly efficient.
Is a fair critique.
So we leave you with this question to ponder. Is the BPL test truly a reflection of our shared sense of communal justice and fairness, or is it fundamentally just an elegant, perhaps cold way to calculate who should bear the financial cost of accidents in an efficient manner? Something to chew on as you reflect on this deep dive.